Can everybody hear me? Okay. My name is Elaine Dahl. Welcome. This is an emeritus pro bono attorney training, but all are welcome. And the topic is strategic and ethical approaches to pro bono. This is funded by a Legal Services Corporation Pro Bono Innovations Grant, and it is sponsored by the Montana Legal Services Association. This training is intended to provide guidance for MLSA pro bono attorneys about strategic and ethical approaches. It is going to be 1 hour. We're not going to get into every possible topic. And this presentation and some other materials are available in a binder. I understand we ran out, but MLSA will provide the binder materials for anybody who didn't get them after the training. If you are volunteering with a different organization, they may have different processes, so this training is just about MLSA's approaches. So, pop quiz. How can you best approach work in MLSA's pro bono program strategically and ethically? A, ask for work nobody else likes to do, even if you don't like it either. B, just get your assignments from MLSA, turn in your hours, and never communicate with them otherwise. C, tell clients that MLSA will take care of all their problems and provide unlimited services. D, it's just pro bono work, so who cares? E, none of the above. Any thoughts? This is supposed to be an easy one. Okay, I'm hearing E. Very good. And oh, I should say as a housekeeping point for those who are listening remotely, if you have questions or are having trouble hearing me, Sarah McLean has agreed to take email questions, and her email address is smcclain@mt.gov. So going on, if the answer is none of the above, what should you do? The big picture takeaways are to remember that both you and MLSA have ethical obligations, and you can be strategic. MLSA has certain protocols, follow them. Communicate with MLSA about what you're doing, just to make sure you're on the same page. Be consistent in your communications with the client, with MLSA, with adverse parties, and with tribunals, and document your work, including outcomes. So why is MLSA strategic? Well, the main reason is that the demand far exceeds the supply. MLSA generally serves low-income people, meaning those at 125% of the federal poverty level. In 2019, that federal poverty level for a family of 4 is $25,750, so that 125% is around $32,000. In 2017, MLSA had about 7,900 requests for services and could only assist half of those people. Of 2,900 cases closed in 2017, 88% were through counsel and advice only. And so that's not a higher level of services. And MLSA currently has 17 case handler attorneys. It was 14 in 2017, and that has to do with grants. And some of those grants limit the types of clients or the types of cases that those attorneys can handle. So there's a great need. MLSA also needs to be strategic because federal regulations limit what they can do. So MLSA receives funding from the Legal Services Corporation, which was established by Congress, I think in 1974, to administer funding to legal aid programs across the country. It's crucial funding, but the funding comes with regulations. And if you ever want a bedtime story, you can read those regulations, 45 CFR 1600 et sec. And there are all sorts of prohibitions and limitations. And just as an example, staff attorneys can't run for partisan elective office. So there are all sorts of things that are addressed by those regulations. And many of the regulations, not all of them, extend to all of MLSA's work, even if it's not funded by LSC. You are not responsible for knowing all of the LSC regulations. You're just responsible to know that they exist so that you communicate with MLSA about what you're doing, and then they can tell you if there's a problem. Another reason to be strategic is staff morale. And case handler attorneys, they want to help people. They're not doing this for big money or salaries. They want to make a difference, but they may feel just overwhelmed by the sheer volume. They may feel like they know how many clients they're not helping, and they may feel like they're not making a dent because they just keep seeing the same fact patterns coming in over and over and over again with different faces. So how is MLSA strategic? MLSA And this was something that I learned when I was a staff attorney at MLSA. The focus is on what you can do, not what you can't, in light of those limited resources and regulations. And so being strategic is figuring out what can you do in light of those limitations. So does that mean the Legal Services Corporation is going to bust in here and say, what are you doing? Are you being strategic? Shut down this training? No, they want these programs to be strategic in light of those limitations in the federal regulations. So there are permissible broad-based advocacy approaches, LSC funds, technology initiative grants. This Pro Bono Innovations Grant is a good example of being strategic. So MLSA, along with other legal aid programs across the country, is strategic both in litigation and non-litigation approaches. So litigation approaches, MLSA will triage cases to decide the level of services to be provided. They're going to consider things like likelihood of success, client characteristics. So if you have someone who can't read versus someone who has experience going to court, that could be a factor. Their available resources, the potential effect on people other than the individual client. So what does that mean? You might hear the term broad-based or systemic or impact work. It's all referring to the same thing. So it's where the outcome of the work affects more than one individual client. How it could change the behavior of an adverse party. So you could negotiate a settlement with a landlord or a property management company to change boilerplate language in a lease. And that's going to affect all of the tenants who are subject to that lease. You could convince a government agency, raise a question and say, hey, the way that you're processing this isn't legal under a certain regulation or statute. And they might be convinced to change how they do that. That's going to affect a whole lot of people down the road. Deterring a bad actor that repeatedly breaks the law. Unfortunately, there are entities out there that prey on low-income people, scam people, and it may seem counterintuitive, like why would you prey on people who don't have any money? It's because they're vulnerable, they're unlikely to challenge things, and desperate people do often find ways to come up with money if they think it's going to get them out of a situation. So deterring those bad actors is another approach. Deciding an issue of first impression, setting precedent can be an important strategy because that'll obviously affect future people. And empowering a client community. So this could be anything from tribal court jurisdiction. If there's an issue where tribal court jurisdiction is really important, that could be something that empowers those people. Or domestic violence, if the Montana Coalition Against Domestic and Sexual Violence says, hey, we keep seeing an issue that's coming up across the state and we're looking to litigate that in partnership with MLSA. MLSA can be looking for those kinds of cases. Non-litigation approaches, you can empower clients by developing know your rights resources, creating forms for pro se litigants, and commenting on court rules that affect pro se litigants. Technology, montanalawhelp.org. For those of you who've been to the prior trainings in this series, I've referred to that a lot. AskCarla.com is a way that attorneys can answer questions when the questions are posed by someone who anonymously, and the advice is also given anonymously, and so that's a technological approach. Video conferencing, MLSA has done some work in telelaw, trying to reach people in remote locations. Long ago, MLSA got a grant for the courts to get video conferencing capacity in courtrooms so that people could appear remotely. And then community lawyering efforts engage potential partners. So MLSA partners with all sorts of people, libraries, domestic violence shelters, tribal organizations, government agencies, other nonprofits, and those partnerships can be really key in their work. And administering a pro bono program. So LSC requires that a certain amount of funding gets spent on private attorney involvement, but each program gets to decide what that means, and MLSA has decided that programs like the one that Angie in the back administers for MLSA is what they want to do. So pro bono attorneys can be strategic. So how are pro bono attorneys strategic? Increasing the efficiency. So MLSA partners with a whole lot of local pro bono programs, but their intake system is a big process, and it can help screen people to determine that they're financially eligible and that they have a case that is eligible for services. the bar partnerships, the state bar and several local bar associations partner with MLSA on many projects. So if you as a bar member have working knowledge of the types of cases that are going on, that can help further those partnerships as you're talking in your local bar. Capacity building, MLSA staff attorneys, those 17 attorneys, they just can't handle everything that's coming in. So you can take on some of those duties. Staff attorneys can be freed up to focus on cases that require specific competencies. So one example would be subsidized housing. That's an area of law that's very regulation heavy, and that's something that not every pro bono attorney is going to be able to do, but you can free up a staff attorney to focus on that. Specific capacity building, so if there's an area of law that MLSA just isn't able to address, they might put out a call and say, hey, we need pro bono attorneys to help with employment law. And maybe you don't have that capacity, but maybe you could work with MLSA on how you could develop that capacity. And then tracking outcomes. Pro bono attorneys can help follow up on cases to discern outcomes and provide feedback to help MLSA improve its services. And this is something that MLSA, I know, is constantly trying to figure out how to better track outcomes, because you don't always know when you do an advice call, did they actually send the letter? And if they did, what happened? So the most strategic approach to pro bono work is to recruit and retain attorneys who are happy with their roles and will keep doing pro bono work. So you can tell MLSA what you want to do. Litigation, if you want that courtroom experience, there is always a need for that, and MLSA is always going to be able to hook you up with a case. If you don't want to be, or if you only want to do limited scope work, and we'll talk more about that later, that's also an option. You can also help clients fill out paperwork or review paperwork that they've already done. You can do advice appointments, either an initial advice appointment or a follow-up advice appointment to find out what happened as a result of that initial advice appointment. I hope that was nothing technical. You can help MLSA develop and review forms and resources on montanalawhelp.org. This may not always be available, but if you're interested in it, you can tell MLSA that you want to help develop those forms that go under review by the Self-Represented Litigants Commission. You can act as a mentor for a newer attorney. So particularly for those of you who are in emeritus status, you have valuable experience. You can share that with newer attorneys. And if you have other ideas, you can ask MLSA's pro bono coordinators, and the contact information for that will be on the last slide. So what can you do as a pro bono attorney to be strategic? You can help spot impact cases by making notes in the file. So if you're just doing advice appointments, that's great, that's welcome. You don't have to take on the full case, but just telling MLSA there's a potential impact case here, that can be very helpful for MLSA. If you want to provide a higher level of services, you can certainly do that, and that'll help free up MLSA attorneys to focus their resources. You can build your skills to develop competency to handle certain cases or to mentor others. And the outcomes, again, you can follow up, do those follow-up calls with clients to help MLSA track those outcomes for grant reporting purposes, and also so that they can decide, hey, do we need to change something about what we're doing so that it'll be more effective. And you can also be systemic eyes and ears. If you're seeing trends, if you have suggestions for MLSA or possible partnerships, the one caveat on this would just be tell MLSA if you're thinking of reaching out to someone else, just to make sure you're not crossing wires or duplicating efforts. But if you have ideas for partnerships, reach out to MLSA and ask them. If you do an advice appointment, how do you decide whether you want to do more in that case? And I want to start with the huge caveat that most of the time you're going to know going in that you're just doing an advice appointment, or you're doing full rep, or you're doing limited scope. But for those of you who are open to doing different levels, just realize that you are not obligated to do more in any case. So you can limit it, or you can decide to do more. If you're going to decide to do more, think about your skill set, and that could also be an opportunity to build skills. Your availability. So if you're regularly doing advice calls and you decide to do full representation in a case, you're probably not going to be able to do a certain number of additional advice calls. Whether you want to help this client in particular for whatever reason, you might just have a connection with this client. But also consider that MLSA's triaged the case, and so unless you're learning something new, there might be another case that MLSA could point you to. So if you want to litigate and you're not sure if this is the case to do it or not, just realize that if MLSA has said this client is appropriate for an advice appointment, there might be another case that they've already identified that could be more appropriate for litigation. So what should you be on the lookout for? Overlapping issues. Sometimes a client, it's very common that clients are going to have more than one issue going on at the same time. So you might be advising on a public benefits issue, and the client says there's a collection agency calling them day and night on a 30-year-old debt that they haven't heard anything about for decades. You don't have to know anything about collections law to realize that that might be a separate issue. And so you could just note that in the file, let MLSA know that that's an issue, and find out if MLSA either, you can ask the person, did you tell MLSA about it, and they might already have a separate file. But if they don't, tell MLSA, hey, there's another issue, and they can decide how to follow up. Client capacity issues. If you believe that your client is displaying cognitive issues, tell MLSA about it, and just realize that there is a rule of professional conduct 1.14 relating to client capacity, including confidentiality of information. But that's something that some clients might have good days and bad days, and they might have had a good day on intake day, and they might not be having such a good day when they're talking to you. So just be aware that you might be able to spot those issues. And special requests. MLSA sometimes will say, hey, we are looking for cases on such and such an issue, so you can help MLSA in finding those particular issues. So a recap just on the strategic part, tell MLSA the kind of work you want to do, help MLSA spot issues, communicate with MLSA about your work, communicate with others about MLSA's work in the community, help track outcomes. And I just want to say on this, even if you don't feel it was fully successful, MLSA needs to know what the outcome was. So if you help a client and they were looking to get $500, and or let's say that they had a $500 debt and you negotiated it down to $300, you've helped that client avoid paying $200. They still have to pay the $300, but that's still an outcome that will help MLSA understand what to do. And attorneys tend to be really hard on themselves, and when I used to do grant writing at MLSA, I would talk to attorneys where they would say, well, we only prevailed on 2 of the 3 claims. Well, you prevailed on 2 of the 3 claims. That's a good thing. So telling MLSA about your effectiveness, and then being a mentor or asking for a mentor. And it may take MLSA a little time to match up mentors with newer attorneys, but it is something that I know this emeritus pro bono project is partly focused on trying to get that mentorship going. So ethical approaches. And I only have one scenario for all of the ethical aspects of this. So you've agreed to volunteer with MLSA once every other week to help clients review their paperwork before they file them. You're willing to do a variety of cases, but your former law firm represented a lot of entities that are adverse to MLSA clients. One day you're helping Candy client review her family law paperwork. After you make a few changes, you think she's ready to go to file her paperwork and to proceed. You don't have time to represent her for the full family law case, but you want to represent her on her petition for temporary orders under 40-4-121. And those are temporary orders that can be orders of protection, financial support orders, things like that during the pendency of the case. So what should you and or MLSA do about potential conflicts for your paperwork reviews just generally? Just jumping up to that first paragraph. What do you think you would need to do for conflicts purposes? I'm sorry? Okay, run through your law firm's conflict list. Any other ideas? Okay. So what about Candy's case? Can you represent her for only part of the case? Is that allowed? Yes. I'm hearing a firm yes. Any other thoughts? Okay. If so, how should you proceed?
Get consent in writing to limit
Okay, so I'm repeating this just for the folks who are remotely. The answer that was said was file a limited scope appearance notice and get the client's writing in consent. And that was in the opposite order of the way that it was answered. But so let's look to see what the answers are. So for those of you who went to law school in Missoula, you may remember Professor Cynthia Ford saying there is a rule, and there are rules in Montana, the Montana Rules of Professional Conduct. The Montana Supreme Court has adopted these rules. They appear in the desk book, and they are prefaced by the orders amending them. For reasons we're going to talk about, the desk book, the print desk book, is not current at this time. This 2011 order, which we're going to talk about a little bit later too, amended the rules to encourage limited scope representation. And in March of 2019, the state bar petitioned the court to revise the rules of professional conduct. MLSA met with the bar during this process, and my understanding is that MLSA said basically our practices aren't going to change, whether the rules stay as they are or whether the changes that the bar is advocating for are adopted. This is attachment A, and again, this is in the binder of materials. Attachment A is at the very end of the petition, and then this just basically lists all of the rules that were affected by the petition. Attachment B is a chart that actually shows what the Montana rule is, the ABA rule, and then what the bar was recommending, and so that attachment is also there. On October 29th, the court ordered that the rules be amended in accordance with the bar's petition. So originally, when I spoke with MLSA about doing this training, we were going to do this one first because we thought that the court would have a decision on the ethical rules. They didn't have one before the first training, but they do now. So the bar's petition addressed more rules than we're going to talk about here, things like confidentiality, organization as a client. It's just a very good idea to read the court's order and the attached revised rules. Those are also in the binder of resources, or you can find them online, and the cause number is AF090688. So this is the overarching rule about pro bono, Rule 6.1. It is not changed. It is a Montana-specific rule, and it is that a lawyer should do 50 hours of pro bono work. And I'm not going to go through these line by line, especially the ones that haven't changed, but so what about conflicts? Rule 6.5, this is, I'm going to guess, one of the least cited ethical rules, but it basically says if you are doing short-term limited legal services under the auspices of a program sponsored by a nonprofit like MLSA or a court without expectation of continuing representation, the conflicts rules don't apply unless you know of a conflict or disqualification. The bar didn't ask for any changes to the rule, and it was not changed by the court. Despite this rule providing an exception, MLSA still does give you the opportunity to do a conflicts check before a call, and that's just because attorneys were more comfortable with that. So this is just a sample email with the client information changed, saying, hey, we've got you scheduled to do an advice appointment. Let me know if there's a conflict, with the name of the client and the adverse. You might hear MLSA staff refers to advice or brief services. That's that short-term limited legal services that's talked about in 6.5. So that's either just an advice appointment or helping a client review paperwork would be examples of those. So again, you're usually going to know at the outset, but you're going to have the opportunity to do this conflicts check, even though there's Rule 6.5. Other conflicts rules, if you're doing further services, are 1.7, 1.8, 1.9, 1.10, 1.11, and 1.12. Just 1.7 has not changed. It's again that concurrent conflict of interest. Is it directly adverse? Is it materially limiting your ability to represent the either client? And if there is a conflict, you can still go forward if you get that consent to a conflict. Rule 1.8, this is the really long rule about various situations like media rights, and Montana has some Montana-specific language about liens and loans between attorneys and clients, sexual relations between attorneys and clients. The bar asked that language, which is pointed to right there, this is about gifts, including if you're doing a will for someone and they're giving you something in the will, This just adds to the number of people that you can do that for permissively, or that you can do that for. So it says, or individual with whom the lawyer or client maintains a close familial relationship. And the bar's comments on the right says that includes domestic partners or close friends that have a family-like relationship. So that's just an addition to that. Other than that, that really long rule, and it's much longer than this, has not changed. The bar didn't propose any changes to Rule 1.9, so it's unchanged. This is former clients, so again, if you're gonna do fuller services for an MLSA pro bono client, doing that check with your firm's client list, as was suggested before. This is what's covered by 1.9. Again, you can get the informed consent in writing in certain circumstances. And then this is imputation of conflicts of interest. There were some substantial changes to Section A regarding screening, and this is just showing everything that was added in. There was already some screening language in Part C of Rule 10. This is really more about what the firm is doing for screening, so just so that you're aware that it's a change in the rule. Rule 111 is unchanged, and my understanding is that there was a training right in this room. This is about government employees and when you're disqualified, but again, it hasn't had any changes under the recent rule changes. And Rule 12, this is again former judges, and this is probably the law clerks would want to know about this one, but again, not changed. MLSA did tell me that they will provide a memo regarding the state policy on pro bono and avoiding conflicts with respect to Rules 111 or 112 on requests. So if you are having some issues with a supervisor or with your agency, you can ask MLSA for a copy of that memo. So just in terms of conflicts, you do need to comply with the ethical rules regarding conflicts. There are some provisions about pro bono work, like Rule 6.5. MLSA will give you the opportunity to do that conflicts check, even though there is Rule 6.5. If you know there's a conflict, obviously, if you realize that you're sitting across a table from someone that you deposed 2 years ago and their name just changed and it wasn't caught, either avoid or quickly terminate that, or if you're doing a fuller representation, it might be worthwhile to go through that informed consent process. And just with ethical rules generally, it's just a good idea to keep in mind the practical considerations. So if you've got a client who you know you were adverse to before and now you're trying to help them with something, just consider it from their perspective. I mean, that's what the ethical rules are about to a large extent, is just keeping in mind the practical aspects of a situation. So for the other part of that scenario, which was doing the limited scope representation, the bar did recommend revising Rules 1.2, 4.2, and 4.3. In their memorandum of support, they basically said that those 2011 amendments that encouraged limited scope representation are no longer necessary. Those changes that happened in 2011 were drafted by Judge Russell Fagg and his law clerk from the 13th Judicial District, and they were really trying to promote pro bono and clarify how you do it, and that was really the point of those amendments. And now the bar has said they're not necessary and they potentially create disciplinary traps. They also said Rule 1.5 requires for fee agreements that you talk about the scope of representation in your fee agreement. And then the bar also said that the ABA rules, which don't have the language that was inserted in Montana's rules in 2011, the ABA has fully embraced limited scope, and they have best practices that absorb the requirements of the Montana rules. So if you're curious and you want to see what the ABA resources are, these are just, you can go to the ABA website, and they do have resources on limited scope representation. They also call it unbundling, and so you can go there. There's a lot of reports, paperwork. There's a white paper on the 50 states approaches to limited scope. So if you're looking for guidance on how the ABA has done things, that's a good place to look. So for Rule 1.2, which is the scope of representation, that whole area that's circled in red, that's what the bar advocated cutting, and that is what the court did. And so all of this, which talks about getting the client's informed consent in writing, and then having a presumption that the representation is limited if you do have that written consent, that language is all gone now. So this is just a copy and paste from the rule as it was attached to the court's order, and you can see that paragraph C is a lot shorter now and just says the lawyer may limit the scope if the limitation is reasonable under circumstances and the client gives informed consent. The bar did refer to Rule 1.5 about fees and fee agreements, and the one change to that rule is that they inserted in paragraph B any changes in the scope, so the fee agreement should now address any changes in the scope as well as the scope itself. So, and this is a much longer rule than this. I'm just showing you what the change is here. Similar to Rule 1.2, Rules 4.2 and 4.3, this is how you communicate with a person represented by counsel or a person who is unrepresented about a case if you are doing limited scope. And they basically just cut the second paragraph of each of these rules. So this is saying there's a presumption that they're unrepresented unless the opposing party has gotten written notice. They've cut this language, but again, they're saying the ABA practices absorb what this language said. So really the practice itself isn't going to change, it's just the rule has changed. So this is how the rules 4.2 and 4.3 look now. Again, they cut the second paragraph of each rule. So what does MLSA do in relation to limited scope representation? So MLSA, before services are provided, whether they're those advice or brief services or something beyond that, they confirm the scope of services in writing with the client. If they are above advice or brief services, so that limited type of services, MLSA does get a limited scope retainer signed by the client. And then MLSA also gives pro bono attorneys a case management guide. I don't think that's in the binder of materials today. It was in a prior training, but if you need that, just let MLSA know and they will give that to you. And then MLSA also gives attorneys forms that they can use if they want to file a limited notice of appearance in court. And then MLSA also closes the case in writing. So this is a template of an email that a client would get before an advice appointment. And MLSA has over 50 years of services in Montana, so they communicate with clients all the time. If they have a problem with clarity in communications, they've probably heard about it. So some of these communications seem a little blunt, but they are very, very clear. So it says, keep in mind that this may be the only help we can provide. The attorney who calls you can only help you by providing you with advice during your phone appointment. The attorney cannot help you in court and cannot provide you more advice. So that's what the client is told before an advice appointment. This is the case management guide. This is what it looks like on the front. And this is just an excerpt of it about conversations with the client that gives you a script that you can follow, and you don't have to say these exact words, but it's just a suggestion to confirm that you're saying this is the only services that I'm providing. MLSA is not committing to representing you after this phone call. Again, just being clear and consistent with the client. This is the limited assistance retainer and the pro bono retainer. There's a slightly different process for in-person clinics regarding retainers and releases, but this is just to give you an idea of what those retainers look like. If it's a full representation retainer, there's a different one for that. Private attorneys can and should do their own retainers in addition to the MLSA retainer, but just be consistent with what the MLSA retainer has said. So if the MLSA retainer is saying it's limited to a certain amount of services, you don't want to do a separate retainer that's saying I'm going to do full representation, because that's going to be confusing for the client. So be consistent. And MLSA will provide template forms to attorneys who are looking to do their own retainers in addition to the MLSA retainers. This is an example form that MLSA can provide that you can adapt. So this is, again, that consent. So MLSA is still encouraging that you do that written informed consent and that you file those written notices in court, even though the rules don't expressly require it, because it is part of the ABA best practices. So this is something that you could easily adapt to say that you're just going to do those temporary proceedings for Candy client. This is a notice of limited scope appearance. Again, you could adapt this to say whatever it is that you need to say, and there's a certificate of service that is on a future page of this. And then the notice of completion of the limited scope representation. So it's important to let the court know and the adverse know when you're done so that they know, okay, now I need to communicate with the client directly. This is a template closing letter after the advice appointment. There's a different closing letter that MLSA will do after other kinds of appointments, but if you're just doing an advice appointment, it says, we've closed your file, we will not be doing anything further for you unless you contact us again. We do not represent you. Again, it's pretty clear language. So some bonus questions. If you're in an advice appointment and something comes up, and let's say the client mentions something and you're thinking, oh, I know there's a statute on point or there's a case on point, do you need to communicate with MLSA before just getting back to the client with that additional information if you're just looking something up? No, you don't. You can just tell the client very clearly, I need to look something up, I'm gonna call you back, let's set a time to do that. It's not a separate appointment, it's just a continuation of this appointment, but as long as you're clear that they're still limited to that one appointment, you should be good to go. What do you do if you're in an advice appointment and the client describes an emergency? And really nothing changes. MLSA told the client they were only getting an advice appointment. You can advise the client of things that they can do. There may be things that they could file or send or people they could call. But you would still need to call MLSA and get those retainers done before you could do anything. And that sometimes just isn't practical. It's not going to happen in if they come in on 4 o'clock on a Friday afternoon and they need to file something by 5. It's just not feasibly going to be done. So it's unfortunate that it happens. You could give feedback to MLSA if you think there's some reason that the case should have gotten to you sooner. You could let them know that, but sometimes it just happens that a client will do something between intake and an advice appointment that accelerates things and creates an emergency situation, and there's not much you can realistically do. So what should you do as an attorney under those rules? Be consistent with MLSA's communications. MLSA has said that she's only getting an advice appointment, so even if you're thinking, I want to do more, you can tell Candy that you're going to ask MLSA about whether further services might be available, but don't guarantee anything because you don't know what might happen once you talk to MLSA, and it's going to be a lot easier to approach Candy later and say, okay, now we do want to give you more services and do the retainer at that time than it is going to be to tell her on the advice appointment that she's going to get more services and then have to back out. Coordinate your paperwork with MLSA. MLSA will get a retainer to Candy doing the scope of representation. You can do your own representation or your own limited scope retainer. Candy's still going to file her own family law paperwork for the big case. Once those are filed, you can file her consent to your limited scope representation and notice of limited appearance, and then ultimately your notice of completion. Communicate with the adverse about the limited scope issues, and if it's not a litigation situation, you can still send the adverse a written notice of what you're doing. I'm helping negotiate this one issue and only this issue. And stay within the bounds. So if you say to Candy, I'm gonna help you only with these temporary orders, and then she asks you to do something beyond that, be consistent and say, well, we haven't agreed to that. I'm only doing the limited scope. I don't know what that sound is. Well, I would say you're in an ethical problem if you go beyond what you've agreed to. I mean, I would say that she could say, if you got brought up on an Office of Disciplinary Counsel complaint, that you gave her the impression that you were doing more because you went beyond that and then you created more. But what do other people think if you go beyond your limited scope and you start doing more? Yeah.
I think you could get a new written consent and limited scope that includes whatever you expanded to, then file another notice.
So that answer was you could do another retainer to expand the scope of what you're doing and then file that with the court. Sure, you could do that. Other thoughts? Yes? Okay, and I'm just repeating this for the folks who are remote, that if you don't do that, if you don't do another limited scope appearance, you could have a judge who says, I'm not letting you out. So you could be on for the full representation. That's a good question. So this is just a recap of the limited scope issues. MLSA does a lot of communications with you and the client. They are designed to help you comply with the ethical rules. Before you promise anything to the client beyond what you and MLSA have already talked about and agreed to do, contact MLSA and let them know what you're thinking. During the advice appointment, if that's what you're doing, stay consistent with the client that they're not going to get any additional service, because that's what MLSA and you have already told them. You can communicate later that they'll get more. And tell MLSA what you want to do and be clear about what you want to do. I only want to do a limited scope, or I do want to do a full rep, or I only want to do advice calls. And MLSA will know that that's what you want to do. Let the adverse and the court know the scope. And you can either do that by filing and serving a notice or by sending written notice to the adverse, and notify everyone when you're done. So this is the contact information. Angie Wagenhals is in the back of the room here, and her email is most of her name. It's awagenha@mtlsa.org. You can also go to the mtlsa.org website, and there's a button at the top that says volunteer, and that'll take you to a page that'll describe MLSA's pro bono program and how you can volunteer. Questions or comments? Does anyone have? Janine. Okay, and I'm just going to repeat that for the folks who are remote. So the court has sent the court order with the new rules to the desk book publisher, so the next edition of the desk book should have the current rules as they are. So. How about the bar website? Yes. Okay, the last time I looked, it hadn't been updated on the bar website, but the court wants it to be. So. It was directed to be sent to the bar website. So okay. Okay, and that's a good clarification. So the new rules are effective January 1st. Other questions, comments? Yes, Sarah. What are some of the biggest demands? I am going to defer to Angie on that, if that's okay. Angie?
Power's on this time. So we are always happy to, we want you to enjoy your pro bono work, so we're always happy to talk to you about what legal issues you want to work on, whether there's something that makes you particularly angry or you think is particularly unfair or something you want to learn. But family law is the #1 demand, followed closely by landlord-tenant issues, representing tenants usually in eviction proceedings or in getting their security deposits back. But we also have a really high demand for people that can help with bankruptcy, Chapter 7 bankruptcies and consumer law issues, employment law issues. Immigration has come up recently, and we do need some help with that. So it really spans a lot of different civil legal issues, and it can kind of fit with what your interest and comfort area is. But family law is always going to be #1, even though I know not everybody wants to hear that. But we'll try and make it as easy for you as possible.
Anything else? All right, well, thank you all for attending, and have a good rest of your day.